So this recording is intended to be a brief history of the Australian legal system. With all histories, we'll try to start right back in the beginning, or at least as far as we can. So a good place to start there is with the Roman Empire. Now, the Roman Empire grew from the Roman Republic from about 27 BC onwards, before sort of collapsing in the West in the late 5th century. Now, the Romans were dominant in the Mediterranean area throughout that period, both Republic and then later the Empire, reaching a height of about 150 AD. They conquered the areas in and around themselves and all the way east up to sort of modern day Iraq. They conquered Northern Africa. They conquered most but not all of the British Isles and a reasonable chunk of what we would consider now Germany. They were just amazing at fighting, at hand-to-hand fighting. They had very well practiced drill and excellent battle tactics. They had large tower shields, good quality weapons, but most importantly they had excellent tactics and discipline. Their battle systems were to lead out with their huge shields, to absorb any arrow fire, and when engaging the enemy, who were often less organised, to be able to put the big tower shield, stab the person 45 degrees on your right, and then when you get tired, to retreat and have fresh troops be able to come through. And it was incredibly effective, notwithstanding the fact that they didn't really have great cavalry. They were pre-stirrup, and they didn't really have the best systems of archers either, but they managed to dominate on land. And so with their complete military domination of their neighbours, they were able to form a large empire. Now, interestingly, the Roman citizens themselves, with some exceptions throughout their history, were essentially on the dole. It seems strange for us to use that term, but if you sort of put yourself in their position of essentially being victors, having the great armies and being able to both defeat your enemy and take their stuff, but also to take slaves. And this sort of consistent theme of who does the work in societies is a constant theme throughout this recording, because the Romans used this workforce that they were able to acquire as a result of their military to build some amazing things. If anybody's been to Europe would have seen all of the systems of aqueducts, of walls, and of amazing roads. It really wasn't until either the 18 or 1900s that the European civilization reached the point where they built roads as good as the Romans have done. And there are still places where Roman roads are still in use 2,000 years later. Australia was one of the founding nations of the United Nations, and I think it's important to note also in terms of the future direction of the law, in that there is and I guess it has been for a long time, a movement towards having international and transnational laws as the nations become more interdependent, more reliant upon each other, and there are more treaties made between nations. The traditional breakdown of the Westphalian model will start to, or rather will continue to make the actual sovereignty of each individual member state less powerful in its own right, and nations will become subject more, I guess, to the influences and power of their peers through these sort of supernatural entities such as the UN. So Just in conclusion, this is where Australia sits in terms of its legal history. I've run through a couple of important steps throughout this process, and I hope that in terms of trying to working out how we got to where we are here, this has been useful. Now, the final area that I want to talk about in depth is as a result of the events that occurred in the 30s and 40s, culminating in 1945. Now, as you may be aware, the three major Allied leaders, Roosevelt, Churchill and Stalin, had a series of conferences throughout the war, and what the results of those conferences were is an incredibly powerful new world order. They were essentially mapping out a framework for the world to be after the war was concluded. It had become clear about halfway through the war that the Allies were going to win. It was just a matter of time. And so, looking at the failings of the entity known as the League of Nations in the 20s and 30s, which was created after the First World War in an effort to try and stop there being future wars, and clearly it was a blithering failure. In an effort to, I guess, rectify the defects with that, the three leaders of the Allies put together this compact in a place called Bretton Woods that really mapped out how the world was going to be. And in particular, it mapped out these supranational entities, the World Bank, subsequently the World Trade Organization, and I think most importantly, the United Nations. Now, the United Nations Security Council is arguably the most important entity on the planet. Why? Well, because the United Nations Security Council can actually authorize the use of force against member and non-member states. This is a complete departure from the Westphalian model, where there is no higher power than the nation state. And really this, the United Nations as an entity and the various aspects of it in terms of trade, in terms of upholding of human rights and protection of things such as the environment and such like. Each of these areas to some extent reduces the internal power of each of the nation states that sign up to be part of the UN. Australian legal. So the next step to take into account in Australian legal history is the creation of Australia, or at least the Federation of Australia in 1901. And now the history there is that you've got 5 competing states, or colonies as they were known back then, all with quite divergent interests, particularly in terms of trade. Now, when you're reading the Australian constitutional debates, and I should say that for those that continue with legal education, that you will certainly be doing this at some stage, you'll note that the dialogue in terms of what the parties coming together to form the federation, what they're really talking about, is really around 2 major areas. The first one is defence. They were a little bit worried that they were going to get invaded, and really that idea of having one army, one large-ish army, rather than 6 small ones, is going to be a much better way of going about defending a very large area. But really the major one that dominated the conversation was to do with trade, in particular trade between the states in terms of tariffs. Again, the largest revenue source for each of these colonies was on tariffs of goods coming between the states. And so the more established states, which this was largely New South Wales, was trying to push all of the other colonies to having low tariffs. Hey, let's have a a free market. Why would they want that? Well, because they already had all the manufacturing in New South Wales. They already had all of the capital, the machines, the factories and so on. So they were in a much better position to compete with the others. Whereas the other colonies, in Victoria in particular, was very, very protectionist. They wanted to protect their own industry, put tariffs on goods coming from elsewhere in order to build up their own manufacturing businesses. And in the end, the free trade argument won. And an important step in federation was that trade and movement between the states is absolutely free. Also, railways formed a big part of this, because the various colonies, they actually had different widths, and so part of moving towards federation was really trying to standardise that. Basically, you got your boat to Albury, your train to Albury, and you had to offload all of the goods and then put them onto another train with a different railway gauge. Seems like a bit of a silly concept to us now, but these issues were big, going back to the late 1800s. Now, they debated the Constitution for a long time. Western Australia, incidentally, only signed up at the very last minute. They were almost not going to be in it. And New Zealand declined to be in it at all, although the Australian Constitution still leaves that door open in the unlikely event that offer gets taken up. Now, federation, though, didn't really mean that everybody living in the colonies, which became states, all of a sudden become Australian. Really, it's a bit of a sliding scale. Most people really consider themselves to be part of Britain, much as the same way that Roman citizens living who'd never been to the Italian peninsula considered themselves to be Roman all those thousands of years ago. And so it was really a slow movement towards giving each of the the countries, the former British colonies, their own independence. The Statute of Westminster was passed by the UK Parliament in 1931, but it really wasn't taken up until well after the war, and Australia didn't adopt it and until after many years after Britain had let them become independent. Now, and it was backdated too, because there was a bit of concern about wartime powers being expressed and constitutional challenges to that. But really, the final nail in the coffin of severing the umbilical cord from Mother Britain came in 1986, where both parliaments passed legislation saying that they no longer will pass any more legislation relating to each other, and there are no more appeals allowed. Now, they'd progressively banned appeals from the federal courts and the High Court, but you could still take a back door, skip the High Court and go to the Privy Council, and they stopped that with the Australia Act as well in 1986. And so at that point, Australian sovereignty was settled. Oh, or was it? An interesting legal development in 1992 actually came from the High Court, where a man from one of the Murray Islands took a challenge, essentially contesting the doctrine of terra nullius, that idea, going back to that principle of Westphalian sovereignty, that Australia didn't have anyone here, therefore it was acquired through the act of settlement. This is, we've come, no one lives here, and this land is now ours. And this, interestingly, is juxtaposed against New Zealand, where a treaty was made between the indigenous peoples of New Zealand and the Queen Victoria, called the Treaty of Waitangi in 1840. And it's an interesting exercise in sovereignty and really unwinding the sovereignty stories of the nations. And I think the two nations in comparison is an interesting point, because what the High Court found in Mabo is that, look, people actually did live here. You may not have thought that they lived here, all of the various colonising types in the 17 and 1800s, and you may not have recognised their civilization because it lacked systematic agriculture, which ostensibly is one of the hallmarks of civilizations that have popped up all over elsewhere in the globe. But nonetheless, there was long-standing cultivation and traditions, and the crown hadn't come to these islands and extinguished them. And so really that opened up the door, subsequently with the Native Title Act that was released the year afterwards, the opportunity for Indigenous people to express that they had some form, admittedly quite a weak form of title, where the British hadn't come and actively extinguished it. So what about Australia itself? Well, Britain, armed with an amazing amount of cash and equally amazing boats, was not only able to win naval encounters, they were also able to embark on scientific missions. And so one of these was the voyage of Captain Cook. And Captain James Cook took a boat ostensibly to observe the transit of Venus, but actually it was trying to determine whether or not this great fabled southern continent existed. And so instead of the great fabled southern continent, what did they find? Well, he found New Zealand, or rather, he re-found New Zealand because people had lived here since 900 AD, and Tasman. The Dutch had actually done this over 100 years beforehand, although they never came back, largely because they ran out of cash. So the British, armed with a lot of sort of financial backing, were able to go send their fabulous boats off and try and discover new lands. And so Cook mapped New Zealand and mapped the eastern coast of Australia, trying to determine suitable areas in which to establish colonies. And that of course leads us to the First Fleet in 1788. In 1788, a fleet arrived at Botany Bay, put up a flagpole and said, "This is ours now." Now that's something of a fiction, both in terms of a legal fiction as well as not necessarily a complete depiction of what actually happened, largely because they didn't really make it to a whole bunch of other parts of Australia, South Australia and the West, for quite some time afterwards. But I guess when picking dates in terms of where Australia exists as a nation, it's certainly a starting point. And I was privileged to go to the 1988 bicentennial they held in Brisbane, an expo, essentially celebrating that date, and particularly the date in late January, celebrating Australia Day, is really the starting point of what we consider Australian legal history to be, as opposed to something different and distinct from Britain. Now the actual laws themselves were a little bit tricky, largely because the colonies of Van Diemen's Land in New South Wales, Tasmania and New South Wales obviously, were essentially run by the military. There was no separation of powers. It would have been quite arbitrary in how things were run and how people were treated. Now, ostensibly, the British laws were what they call received into Australia in 1788. But there was a little bit of ambiguity to that. Why? Well, the whole point of this reception of British law is that, well, you take it into the new country and adapt it as you need to when you get there. And so that there are some things which are just patently obvious, are very, very different about Australia in comparison to the British Isles. One of them, of course, is the vast quantity of land. And so the idea of things like pastoral leases, these things are quite alien to Britain, where you've got relatively much smaller amount of arable land to deal with. Other things to deal with the fact that, well, it's essentially run by the military and had been for quite some time. So there was a bit of ambiguity early on, and so that a piece of legislation was passed by the UK Parliament setting up a court in New South Wales to try and clarify some of that ambiguity. And then later the Australian Courts Act to sort of say, look, okay, you were supposed to have received the law when you first arrived, but we're just going to make it really clear that earlier date, 1823 for the Supreme Court Act, that's going to be the date by which English law was deemed to be received in the colonies of what are now called Tasmania and New South Wales. Now, Victoria and Queensland are actually carved out of New South Wales, so they have the same date for that reception of British law, whereas the other states, Western Australia, South Australia, and, as I hate to say it, New Zealand, which was also part of New South Wales, all have different dates for this reception of British law. Something else happened in the year 1776. A Scotsman by the name of Adam Smith wrote a treatise, a work called The Wealth of Nations. It's a very important text. In fact, some people attribute the entire discipline of economics back to this particular work in 1776. And Smith made a systematic and thorough inquiry as to how do nations and entities build wealth. And amongst many things, and all of these are subject to heavy criticism, of course, over the years, is that people respond to incentives. It's really a hallmark of the discipline of economics. But Smith noted that the people that, for example, were supplying these shipyards, these government-run shipyards, building these boats, the people that were making these pins, the people that were bringing the timber in, creating the rigging, making better and better guns, they're not doing it because they love Britain. They're not doing it because someone's pointing a gun to their head. They're doing it out of their own self-interest. They're working hard and they're using their own capital that they've either built up over time or inherited to actually supply other entities, be they government or private, with better and better products. And they're doing it to make a profit. They're doing it to be better off themselves. And this is a really important consideration in British legal history, because a lot of the cases that we deal with, a lot of this sort of contract law that's mapped out in the common law in the 1800s and again in the 20th century, really flows from this foundational idea that two parties are coming together, and in theory, if they're both of sound mind and with full information, they trade something, they're both better off. And if we repeat this process many, many times throughout our economy, as Smith noted, then the economy becomes very, very powerful. The country is much better off as a result of their having lots and lots of contracts amongst people. So the courts had to adapt, and again throughout the Industrial Revolution, which followed, the courts had to develop common law rules to adapt to all of the various types of contracts that were being made throughout the Industrial Revolution. A lot of these things weren't Parliament driven. They were the courts of common law having to really sort of create laws on the fly in order to adapt. And again, Australian legal history owes a great debt to that, and this the necessity to do that in the course of the Industrial Revolution was mapped out by Smith in the year 1776. So I'll draw your attention to the year 1776. Now, by this stage, Britain's dominating. Throughout the 1700s, it reached a point where it even felt sufficiently emboldened to essentially pick fights with some of the other naval powers, the Spanish, the Portuguese and the Dutch, pick fights with them and then confiscate lands and territories as a result. Now, the year 1776 is actually important. There were a couple of important things that were written and that happened in that year. One of them is the American Declaration of Independence, they had a revolutionary war and decided they didn't want to be involved with Britain anymore. And the British fought them, and then subsequently the 1800s fought them again, but really that was the turning point whereby North America heads off on its own. And again, I think it's an important point to know from a legal history perspective, because 1776 is a really long time ago. And we think about other Commonwealth nations, so Canada, New Zealand, the various Pacific nations, leaving the fold and sort of going out on their own as separate nations. But that happened a long time afterwards. I mean, Australia was a federation in 1901, but the Americans lived a long time before that. And so what that means is that their court and their legal system, while it is still common law and based on the British common law ideas, and that the judges do actually make law as part of that process. In terms of the doctrine of precedent, it's such a long time that the Americas were sort of part of the British fold, that really judgments that come out of the US really cease to have any form of a practical, persuasive, binding force from about this point onwards. Now I'll just turn to some of the key economic challenges and problems of the times. You see, in the late 1600s, France had started to become a very powerful player in the New World, and England was a bit of a bit player in the New World, which was still dominated by the large but nonetheless declining powers of Portugal and largely Spain. Historians really tried to sort of pinpoint what made England and later Britain become powerful, I guess, the dominant sort of naval power. And if one has to put a finger on it somewhere, the creation of the Bank of England in 1693 was certainly a very salient point. You see, the English had just lost a series of naval battles to the French and were broke. And so some of the nobles, some of the parliamentarians, with a bit of expert advice, suggested that they set up an institution whereby people, and by people it doesn't even necessarily extend to just the nobles, ordinary people could put money into and receive interest, and that interest and the principal repayable is backed by the state itself. In other words, the government will guarantee that you get your money back. Now this is pretty novel. It's not to say this was the first bank, but it was certainly a very pivotal moment, I guess, in the history of commerce, because armed with a whole bunch of cash, the English and then later the British, after the Scotland and England united in the early 1700s to become Great Britain, armed with this cash, the English and then subsequently the British were able to build boats. And they were able to build better and better and better boats. Why? Because most of the revenue for governments of the day was through import tariffs. And so as a maritime power, Britain being an island, it was able to build more navy boats, which meant that it could protect its merchant boats, which meant that more merchant boats were getting through unimpeded from other countries who would happily take them over or sink them. And so the result from this is sort of an upward spiral whereby you've got more cash. So what do you do with it? Well, you spend it on building bigger and better boats. And that's what they did. And so throughout the 1700s, the British started to rise from being a bit player to really becoming almost like the first global superpower. It was able to spend more money on the technology of the boats, So this was not just the actual structure of the ship, although they did do that. They put copper plating on so that things could turn a lot faster. They spent more money on the design and the rigging. But it also meant that other parts of the economy, the British economy, would benefit from that. Why? Well, because when they would have these shipyards, they needed a lot of materials, both raw and sort of lightly manufactured goods. So they needed planks of wood that could be bent to put it in place. They needed rigging to be built. They needed cannons to be built. They needed the cannons to be better and better over time. They needed all sorts of stores and ways of supplying them the boats. And they needed nails, big nails that hammer the planks in together. And so what happened as a result is that individuals, people, were able to supply the British boat building facilities with products. And this really turbocharged the economy and started to turn Britain, again, not just the first maritime superpower, but also a powerhouse manufacturing nation as well. Now the Bill of Rights, the British Bill of Rights, has a list of things that are, again, much like the Magna Carta, are really designed to heavily curtail the absolute power of the monarch to do things arbitrarily. In particular, it sought to address things that James and Charles had done, one of which was not bother to call Parliament, by stating that, look, you have to call Parliament regularly. You can't imprison people for saying bad things about the king in Parliament. Essentially, that sort of starting of the right of parliamentary privilege. The king was no longer to have a standing army in peacetime without consent of Parliament. The king can't levy any form of taxes without the consent of Parliament. It's Parliament's job to do that. And importantly, the king can't suspend laws or dispense with them without full consent of Parliament. So the long-lasting effect of the Bill of Rights is that this curtailing of the absolute power of the monarchy really leads towards the notion of parliamentary supremacy. That idea that Parliament becomes the true source of lawmaking, and the other arms of government are in some ways subordinate to that. Another thing that comes from the Bill of Rights is that the election of members of Parliament shall be free, or at least free of interference from the king. Not to say, again, that all citizens and so on would be able to vote. That came quite some time later. So the Bill of Rights is really a very important step towards a contemporary forms of governance, and I guess our modern way of looking at the separation of powers. So I mentioned that England wasn't really party to the Treaty of Westphalia, largely because it wasn't that heavily involved in the 30 Years' War. England's often involved in wars in and around the continent, so why were they not involved in that particular time? Well, they were having a war amongst themselves. In 1642, the English Civil War started. It lasted for about a decade. The English Civil War was really a battle between those loyal to the king, who was originally Charles I until he got his head chopped off, but also those loyal to the royal system and the monarchy itself. And they were fighting against the Parliament, the Roundheads, who were led by a charismatic but very gruff man called Oliver Cromwell. What happened? Well, Parliament won, which sounds like a good thing, but actually it wasn't. And that leads us to the next point. The reason why it wasn't that great was that Cromwell himself, who then ended up ruling as an autocratic sort of dictator for a decade, Cromwell wasn't a really fun sort of guy. He was what's known as a Puritan. And so Puritans, I guess part of the philosophy is to try and remove things that are fun. So there was this outlawing of things like singing in public or dancing or drinking. And so after after Cromwell died, by the way, he also, and after spending all this time and effort in his entire life overthrowing this terrible system of handing the rule, the monarchy, from father to son, he put in place the person to replace him as his own son. An irony which wasn't lost on the people around, and so fortunately his own son wasn't as charismatic or powerful, and he was quietly shirt-fronted, and Parliament actually brought back the old king, which seems a little bit strange, but Charles II, so the son of the king whose head got chopped off, got returned to the crown, and all was good. Why? Because he let people do fun things again. Now, this wasn't particularly problematic for the time that Charles was alive, but was a little bit more problematic after his brother James took the throne. And the problem with James, which was a problem for a lot of, or I say a vast majority of the people in England, was that James was actually a Catholic. It doesn't seem like a problematic thing now, but in the times, and this kind of makes sense, the Pope and I guess the Catholic system was still representing in some ways the Roman Empire dominant over Britain, rather than it having its own sort of sovereignty, its own place in the world. Now, what happened was to James is that he quietly got shirt-fronted and was replaced by a pair of Dutch royals, one being his daughter who was raised as a Protestant, and William. So William and Mary became, at the invitation of Parliament, became the new monarchs. And one thing that they were very careful to do at this time was to write out a list of things that the incoming monarchs could and couldn't do. This structured document goes about explaining what the underlying powers of the monarchy are. And the name of that document is the Bill of Rights. Now, one thing that Europe didn't do, even though it was now armed with increasingly more and more wealth that was coming from the New World, one thing that they very unfortunately chose not to do was to stop fighting amongst themselves. And so there was war after war after war in Europe. Now, one particular war, known as the 30 Years' War, culminated with a series of peace treaties in the year 1648. Now, interestingly, Britain, for reasons I'll explain later, or in England I should say, wasn't involved in that. But one thing that scholars do look back upon was this particular treaty. Not in that it stopped all of wars subsequently, not at all. But what it does do is to map out the rules of warfare. And I think most importantly, it starts with the precept that nation states recognize the sovereignty of other nation states over their territory. That's not to say that the nations like each other, or that they, if they could, wouldn't invade each other and conquer. All it does is saying that we accept that these other states exist, and really that's the foundational aspect of this idea of what we refer to as Westphalian sovereignty. The nation state is the highest form of government. There's no higher power to appeal to. There's no sort of supra national entity. And it really is that idea of might is right. Now, in the Australian context, there was another thing that came from this Westphalian sovereignty, and that was the way to go about taking land. And really there were a couple of ways to do it. One was just simple, you conquer them. The idea is, though, if you conquer someone, until you expressly remove or do otherwise, the existing laws stay in place. Okay, so the existing rules and customs and traditions and laws remain in place until the conquering power does something about it. That's the first way of acquiring land. And the second one is through a cessation or treaty, usually through negotiations of some sort, and sometimes it can be as a result of losing a war. Land is ceded from one country to another, and then it becomes part of that nation and is available to take on the laws of the nation to which it's ceded to. And the third way, which is quite relevant to Australia, is this idea of settlement, of colonising land that belongs to no one. So going back to 1648, there were still tracts of the globe that were unexplored. And so the part of this framework was that, look, if no one lives in the place, provided you can take it and demonstrate that you've taken it, put your flag up, start to build things, start to cultivate the land, that clear demonstration of civilization. Once you're farming there, it is demonstrated to be yours. And that's how countries get to acquire new land that isn't already owned by other powers. Now, one of the sadder tales in this history piece is what happened in the New World after Columbus. You see, the Spanish and the Portuguese were able to send ships across, and those ships could contain, the hallmarks of Western European power and history. And with those four things, they were able to dominate and exterminate and enslave the peoples of the New World. And those four things historians point to are guns, horses, steel, and germs. The last one being particularly problematic, and by most estimates, between 90 and 95% of the indigenous people of the Americas were killed through some sort of germs and disease. Now, the Spanish and the Portuguese were able to send their troops to go and conquer these lands. And to begin, it was pretty crude. We go and we kill the people, we take their gold. Over time, though, they realised that the Americas were far more of an important resource than that, and so that they created a quite hideous system whereby they would take ships to Africa with manufactured goods from Europe, collect slaves by paying with those manufactured goods, take the slaves to the New World, and then take the produce of the New World, be it gold or later on the harvested foods, rice, sugar and so on, take that back to Europe, with very favourable winds. And so that awful cycle, that continued for hundreds and hundreds of years. But originally, it came down to the Spanish and their ability to conquest. Their conquistadors, armed with horses and superior battle tactics. Now, one of the, sad but quite consistent themes here is the idea of slavery in terms of doing the work, both originally in the mining of gold and then later on the working of the plantations, were done by slaves. And this continued for hundreds and hundreds of years, and not just by the Spanish. Other groups got onto it, other nations got onto it at some stage later. But it's an interesting point to note, though, that idea that slaves and slavery, slaves don't make good employees. Why? Well, because if you're a slave, usually the main reason you're a slave is because somebody's pointing a spear at your head, or a knife at your head, or a gun at your head. Or there's that threat, that overarching threat to you and your family and your well-being, and that's why you work. But there's no incentive to be entrepreneurial, to work hard, and that's an interesting point that was captured by some of the later writers in the Enlightenment. Now, the Byzantine Empire was very much grounded in trade, and the 1,000 years or so that it was in existence controlled a lot of Asia Minor, what would be considered modern-day Turkey, along the eastern half of the Mediterranean, and all the way through northern Africa. Over time, though, the Byzantine Empire fell into decline and lost the outlying territories. And with the rise of Islam, is seen as, I guess, a proportionate decrease in the power of the Christian-based Byzantines. So by the time the year 1453 came around, where the Ottoman Turks just came to essentially just wipe out the final remnants of the Byzantine Empire, it was very, very small. Now, this left the city-states of Europe, and by this stage the Roman Empire on the western side has long since gone, and so the various city-states of the Italian peninsula and other places in southern Europe were faced with something of a problem. You see, at that time, from about sort of 1200 onwards to the fall of Constantinople in 1453, they'd been undergoing something of a renaissance. In fact, actually it was called the Renaissance, where there was a trend for rediscovery of ancient world mathematics and texts, and an increase in patronage to the arts, and also subsequently more money going into researching science. So the fall of Constantinople and its subsequent taking over of all of Turkey and that region by the Turks left the Christian city-states in southern Europe with something of a business problem to be solved. You see, although it seems like a contemporary phenomena that manufactured goods come from China, this has in fact been the trend for thousands and thousands of years. All of the good stuff would come from China. And so there was an ancient trade route, very, very dangerous and long overland trade route called the Silk Road, whereby merchants would go in stages all the way across land in a very, very long and dangerous journey to basically trade for the best stuff, the most amazing manufactured goods from the major Chinese cities. Now, the Ottoman Turks, though, they had no love of the Western Europeans, and so one of the problems that was facing the cities like Genoa and Naples and the various Spanish and Portuguese centres was that they couldn't get Chinese goods through the Silk Road. So that caused something of a dilemma, a business challenge looking to be solved. And at first they tried taking boats all the way around. Now that's a very, very long and dangerous journey to go all the way around the western side of Africa, up the east coast, avoiding pirates all around, terrible, terrible coastlines and weather. You've then got to endure tariffs and taxes as you travel across the eastern side of Africa, around the past the Red Sea, past the Gulf of Arabia, all the way to India, and then come all the way down past the Straits of Malacca up through to China. It's a very, very long and difficult journey. And so, in the year 1492, one of the sort of city-states in Spain and Castile set about to try and find a western route to try and get to what we know as sort of the Orient, to China, to Japan, to India. And so this western path or passage was slightly complicated by the fact that when Christopher Columbus and his boats made it to what we call now the Caribbean, they thought they were actually in Asia. You see, while humanity has known the Earth's been around for a very, very long time, contrary to certain history myths that said that Columbus's crew thought the Earth was flat. The Earth was never thought to be flat. But one problem they did have is they didn't accurately estimate how big the Earth was. So they genuinely thought in the Caribbean that they were just sailing around the Philippines. They thought that eventually they would find these cultured people with wonderful manufactured goods. That never really occurred, of course. And what it did do, though, is what's known as the Columbian exchange. So you've got the New World and the Old World coming together, and it started in the year 1492. Now I'll just pause from Britain and would like to return to the Roman Empire. Now, most of you are aware that the Roman Empire, which was centred around Rome, fell into decline and was repeatedly sacked by Goths and other tribes from northern Europe, the sort of 400, 500 AD. What's less commonly known, though, is that the eastern part of the empire, based around the city of Constantinople, which was founded on the Greek city of Byzantine and is now modern-day Istanbul, it was the centre of the Byzantine Empire, which was really the eastern part of the Roman Empire that endured in one form or another for almost another 1,000 years. Now, in a similar vein to the Romans, this system, well, it worked okay for a while, but as with the Roman Empire, you have a series of good kings, and then you have some not quite so good kings. And so it's by no coincidence that the king in the year 1215 was King John. And you'll note that no king of England has ever had that name ever again, despite it being a very common English first name. Now, King John wasn't the best of kings and had a habit of raising taxes and doing some arbitrary things with the royal coffers. And the guys who were just below him on the hierarchy, the barons, they got a little bit miffed at this. So much so, and this sounds a little bit, well, it would have been treasonous, but they were sufficiently brave and emboldened to essentially shirt front the king, took him to a place called Runnymede, and got him to sign a document signing away some of his arbitrary God-given powers. That document, the Great Charter, is more commonly referred to in the Latin, the Magna Carta. Now, the Magna Carta stated that the king was no longer above the law. It's a very, very important principle in terms of this development of the separation of powers and the rule of law. And certainly in the British tradition, it traces back to this document. It also noted that the king is not allowed to arbitrarily imprison subjects. The king must use the mechanics of law in order to go about doing such things. And importantly, the king has to call the barons together, a group of barons collectively referred to as the Parliament. Not the Parliament as we would think it now. They were really the group that fell below the king in terms of dominating the entire land. There was no sort of process of voting, such like, but the king was required to call those people whenever he wanted to raise an army or to raise taxes. And I'll note that the Magna Carta, when they refer to free men, they literally are only referring to men, males, in the what would we consider to be the nobility. They weren't referring to 99% of the population, the serfs, the people that worked on the land. The concept of citizenship as a notion of people actually having rights was not to come for 500 or 600 years after the Magna Carta, but it is still a very important foundational document and really the starting point of the conversation towards our contemporary modes of government. Now, there are many theories as to why the Roman Empire finally fell. Some attribute it to the conversion to Christianity later in the piece. Others in terms of the battle tactics that were no longer quite as effective against their adversaries. Another quite powerful theory is really to do with leadership. That idea that, well, for every good emperor, there are a series of bad ones. For every Marcus Aurelius or Augustus Caesar, there's going to be a Nero or a Caligula ready to lead the empire into some form of inevitable malaise and decline. So what of Britain? Well, Britain was a pretty tiny province. The Romans invaded about 55 BC, and they left, or rather said that Rome was no longer going to help them, in about 400 AD. And there were also lots of packets, it must be known, lots of packets of Britain the Romans never even went to, in the northern parts of Scotland, the Orkney Islands, and to be honest, all of Ireland. Now, so that's not to say that there weren't Roman people still there and that Roman culture didn't influence Britain, but from about 400 AD, Rome as an authority stopped having any influence over the British Isles, and they went back into, well, fighting amongst themselves. And this went on for hundreds and hundreds of years, with various kings rising up and then being defeated. However, a very pivotal event occurred in the year 1066, where the Duke of Normandy, William I, crossed the English Channel and defeated the King Harold, at a place called Hastings. Now, the manner of this defeat was drastic, and again is a very, very good example of sovereignty being created through force. William, in conquering the indigenous English people, became the new king of their land. It's an excellent example of sovereignty being derived through might. Why is William now a king? Well, because he killed the old one. He has a big army, and if you don't like it, well, you can fight him if you like, but you'll lose. And so, from that point, William becomes king of all of the land. Now, clearly, William, both himself and his sort of direct subordinates, they can't be in every spot at once. They can't actively assert their control themselves. So, William quite wisely set up a system of delegation. And the idea of this structure is that there's a pyramid. William, as the king, is at the top, and just below him are a series of barons. And they control large tracts of land throughout England and Wales. And those barons themselves, they can't really actively control the whole area, so they essentially create subordinates, knights and earls below them. And this process of what they call subfeudination is really the basis of what we refer to now as the feudal system. It's a pyramid, and the king is on the top, and then the next layer, the barons, just under him, and so on, all the way down to the actual people who live and work on the land. And the word to describe them was serf, from the Latin servus, meaning slaves. They were essentially slaves on their own land. Why? Because they didn't own any of the land. They just owed a duty to their local lord to provide her or him with food and money, and occasionally things like religious services and military service. And that was owed up to the next level, the next layer above him, and so on, all the way back up to the king. The king is the absolute head of this feudal system. There are very few people who don't work on the land, and those that largely do are merchants, nobles, and clergy. So that really most of your people are just having a subsistence living on the land. Now, one other thing that William did do was to try to express his version of the law. Now, the difficulty with having a reasonably large area, it doesn't seem large by modern standards, but for a medieval ruler to look after, it was quite a large tract, and lots of little tribes with little customs and their own little laws for particular areas. And so what William did, and his subsequent heirs continued to do, was to send out representatives of the crown to act as judges in each of those places, with the idea being that William's law was to become the standard law across the land. And in fact, this process of making the land common across all of England, is where we get the expression the common law. It's all about the king trying to make the law the same across the entire country.